And our first speaker, this gentleman come from Indiana to be here with us today, Attorney Mick Harrison.
So my name is Mick Harrison. I'm a public interest lawyer. I do mostly whistleblower protection. Have been doing that for 25 years. I also do government oversight work and environmental enforcement for citizens groups. I'm a part of a new organization. It's called Lawyers Committee for 9/11 Inquiry. And 3 other lawyers on this panel with me are members of that relatively new organization. Our purpose is to provide legal expertise and resources to the 9/11 Truth and Justice movement as best we can. Our resources are limited at the moment, so don't immediately assume we can, file a bunch of lawsuits for you. But we are interested in making sure that the movement gets the benefit of legal expertise and that we use the legal tools available to promote 9/11 truth and justice as best we can. So what I've been asked to do is to basically put you through law school in 10 minutes, which I'll do my best to do, and then to summarize 14 years of litigation in 10 more minutes, and then to give you the solution to the problem in 5 minutes. And my colleagues will help supplement that with another 20 minutes or so. So, in short, some of the legal tools that are available to the movement, most of you know about the Freedom of Information Act, a very valuable tool. It's one of the few laws that has been used with some success on this issue. So Mr. Green, who's with us, has done some successful FOIA work. David Cole, who's not here, who is my client, has done quite a bit of successful FOIA work on this issue. My colleagues in Bloomington, Indiana, with the 9/11 working group there, have done quite a few successful FOIAs. So our knowledge base has improved because of use of this law, and I continue to encourage people to use it. If you need help understanding how to use it, I'm happy to help if I can. The short and long of it is the government has 20 days upon your request to give you any documents in the control of a federal agency unless they're exempt by law. If they refuse, you can first file an administrative appeal, and if that doesn't work, you can go into federal district court and compel the production of the documents. The courts are pretty good about compelling production of documents unless they're truly exempt under the law. So keep this law in mind. In addition, as another tool, not as well known, the Information or Data Quality Act allows citizens to challenge a federal agency's technical work or their contractor's technical work as not using basically the best science available. And you can actually file an administrative appeal, and if they don't make the corrections that you and your scientists point out are needed, and obviously issues regarding the destruction of the buildings comes to mind on this category, you can actually bring a lawsuit to compel the agency to correct the data if they're using, for example, the wrong data, inadequate data, false data, misleading data. So keep that law in mind. There are also a number of whistleblower laws, too many for me to even list at the moment. But if you are someone who has inside information on what happened on 9/11, or if you know someone who does, depending on who they were employed by and the nature of their knowledge, they are protected by any one of a number of laws. For example, one of the other tools that really hasn't been used much on this issue is called the Federal False Claims Act. This federal statute is intended to protect the federal treasury from dishonest contractors who steal money from the federal government. Now, there have been a number of contracted studies done related to 9/11. If you or someone you know has knowledge that there was any dishonesty in the conduct of those studies, then it's possible that a suit could be brought under the False Claims Act. The way the law works is if you prove up fraud or dishonesty, the court determines the amount of damages to the government, which can often be the money that was taken under false pretenses. That amount is tripled triple damages. That amount is paid back to the federal government. The plaintiff, which could be anyone, a whistleblower or a citizen with knowledge, keeps a percentage of the money recovered as a reward or a bounty provision. That percentage is typically 20 to 25% of the amount after it is tripled, which in the case of multi-million-dollar contract can be a sizable amount of money. This law has been used for the past 20-some years. Billions of dollars have been recovered for the federal treasury. So keep that tool in mind. Now, it has a whistleblower protection provision. So if you or someone you know worked for one of these contractors, and if they disclose dishonesty in the performance of the study and they get fired, they can sue under this protection, get their job back, double back pay, attorney's fees, and so forth. And there are too many whistleblower protections to mention, but if you know someone who has been retaliated against or is in fear of retaliation, get them in touch with a lawyer who knows this area of law, because there are protections out there. In addition, most of you know that family members of the victims and the first responders in separate class actions have litigated for money damages, and they've recovered hundreds of millions of dollars have been paid for those type of class actions. That's another tool that's out there. One other tool I'll mention, in addition to ones that you, I'm sure, have heard about, like civil and constitutional rights claims. If in one of these prior litigations, some of which we're about to talk about, evidence comes forward that there was dishonesty during the litigation, and one of the parties lied to the federal court, usually this is federal court, there is a body of law which allows the case to be reopened based on fraud upon the court. So you shouldn't assume that because the case has been litigated and lost, that it's over if you can prove, or someone can prove, that there was fraud involved in the litigation. So just keep that in mind. Okay, now I want to talk briefly about some of the litigation that has happened and what inferences we can draw from that, and have my colleagues help me in a couple of instances on that. One of the first cases, and the only case I know about that really went to the heart of 9/11 truth theories that was filed, was William Rodriguez versus Bush Cheney et al., filed back in 2004, 2005 timeframe. The plaintiffs alleged, and this was done by Attorney Phil Berg out of Pennsylvania, basically the theory that some of us call "let it happen," that the government allowed the terrorist attacks to occur. It also alleges destruction of evidence by the defendants. It alleges controlled demolition of the Trade Center buildings. It actually, somewhat to my surprise, alleged election fraud, which I find to be an interesting connection, which I don't have time to go into in a moment. It alleged violations of RICO, which is another tool that's out there for people to use. If you don't know what RICO is, it's the racketeering statute, Racketeering Influence Corrupt Organizations Act, designed to fight organized crime, but it can be used in any case, including by citizens, if you can show a pattern of federal criminal law violations of certain types, and that's what was alleged here, and that includes mail fraud, wire fraud, major crimes like murder, and so forth. It's a powerful legal tool, but it's the courts aren't particularly friendly to it, and you really have to have your act together before you try to do it. So I wouldn't go out there and do one of these on your own, for example. I would get a legal team together before you try RICO. It also alleged a cause of action under the Anti-Terrorism Act. It alleged war crimes, crimes against humanity, international law violations, and basically murder of the passengers on the planes. So it was really going to the heart of what a lot of folks are concerned about, having the truth come out on in these movements. Now, I'm sorry to report, if you haven't read about this case, and you probably won't be shocked to hear this, that it was dismissed. Now, it was dismissed on immunity grounds for the federal defendants, and immunity is a significant obstacle, but it's not insurmountable. However, if you want to get involved in a case against government defendants, I would encourage you to involve lawyers who've done immunity issues before. I'm not really one who suggests you always need a lawyer to bring a lawsuit, because you don't. Citizens have a right to represent themselves in some cases. But when you get into complex issues like immunity, a lawyer can be helpful. So they lost this case on immunity grounds against the government defendants. There were other defendants who were later dismissed, basically because the lawyer chose, I think, not to proceed against them, having had the government defendants dismissed. So that case, as comprehensive as it was, really didn't go anywhere. There's been a case that's actually still pending on appeal, I believe in the Ninth Circuit. It's Saleh, S-A-L-E-H, versus Bush. It's on behalf of Iraqi refugee, and it alleges that the Iraq War was planned since 1997, that the motives, and this is, as you might guess, against Bush et al., the motives were financial enrichment of the defendants, personal financial enrichment, and that the Iraq War was a crime of aggression. It is a claim brought under the Alien Tort Statute, which applies to folks who are not American citizens. And again, immunity was raised as the defense, and there were some interesting arguments made by the lawyer, Inder Komar, Esquire, and I thought they had quite a bit of merit as to why immunity would not apply. He argued judicial estoppel based on the Nuremberg trials, where the government took the position that German government officials did not have immunity for crimes of aggression, and he also based it on a British case, on the Pinochet case, where the British courts found there was no immunity for torture and for violations of international law. I'm sorry to report that his case was dismissed in 2014 on immunity, but he has appealed that and is pending in the Ninth Circuit at the moment. There was a complaint in France based on torture allegations against Rumsfeld. Some of you know about that. It was dismissed by the prosecutor on immunity grounds also. So it also didn't go anywhere. Many of you know of Sybil Edmonds, the whistleblower, the translator for the FBI, I think, maybe the CIA also. She brought a whistleblower case, constitutional claims, Privacy Act claims. Her case was dismissed on another legal technicality, the state's secrets defense. And basically, without getting to the merits of her allegations, the court decided there was no way to litigate her claims without getting into national security issues that were classified. And so basically the doors to the courthouse got closed on her as well. Now, we are fortunate to have my colleague Mustapha Ndanusa with us, who did the April Gallup case. And Mustapha, would you mind giving us a short summary of what happened in that case?
Sure. Can everyone hear me? No? Better? Okay. So my name is Mustapha Ndanusa. I'm an attorney here in New York. I'm based in Brooklyn. I started my practice basically representing the underserved people in the mental hygiene world in landlord-tenant cases. And I got involved in the April Gallup case, actually from listening to the Alex Jones show. And the attorney that drafted the complaint in the April Gallup case, William Veal, was on. I was intrigued. I called him, and I got on basically to help them as local counsel. What that meant was that I was going to be filing the case for them electronically. Federal cases are almost entirely done electronically, except for the first document that you file. Bill was accompanied with Dennis Cunningham, who's another attorney on the case. Neither one of them can practice in the Southern District, so they had to get admitted to the Southern District, and I was basically the person that was going to get them admitted to the Southern District for that specific case. And that was the role that I played, in addition to sometimes giving them some advice on some legal theories. So April Gallup, just to sort of give you a quick synopsis of her story, is really long, but what I found most intriguing about her case is actually the beginning of her case. In order to file a lawsuit against anyone, you have to have an injured party. Basically, that's the person that's been affected, the person that has standing to sue, to make the claim. And April Gallup was the person that has standing because she was injured on 9/11. She was working for the Pentagon. She's an Army specialist, had been working for about 6 years, 2.5 years in Germany, had high-level clearance. And on September 11th, she was returning from maternity leave, and she had a 2-month-old child with her. Headed to the Pentagon, as she assumed was going to happen. that when she gets to work, they're going to tell her that she has to take her child to daycare. She has to go through a whole long process for the daycare before she get to her office. She gets to work, she was just, the doors are open, go straight to your office. No daycare, nothing, just go straight. But no alarms, nothing. We know that there are planes headed to Washington, D.C. Nothing is sounding in the air saying that we should be concerned. So she thought that was kind of odd that the doors are sort of like open for her to just take her child to her office without having to go to daycare. Goes to her office, turns on her computer, presses a button, boom. Initially, she actually thought that maybe she did something to cause this. Her child goes flying out of the baby carriage. She's knocked unconscious. She wakes up and she comes out of what I believe what basically was the hole that was created by whatever it is that hit the Pentagon. So we filed an action in the Southern District of New York. And now, mind you, this is the Pentagon, which is in Virginia, right? Why is this case in the Southern District of New York? Well, there's a special law, I think it's the Special Provision of Air Transportation Safety Act that says that all actions arising specifically out of the September 11th incident that are civil litigations have to be brought in the Southern District of New York. I want you to keep that in the back of your mind for a little bit later. So he brought the lawsuit alleging, among many other things, anti-terrorism, Bivens, which is basically constitutional claims against government actors for injury that you suffered, constitutional violations, retaliation, because April refused to basically concede to the official story that a plane hit the Pentagon. And once she did that, she was stripped of her medical care. She just had a lot of running around that she had to go through just to get the medical care that she was entitled to. The defendant, of course, were Richard Meyer, Dick Cheney, or otherwise known as the man who shoots you in the face and then has you apologize to him for shooting you in the face, and then Mr. Unknown Unknowns, otherwise known as Donald Rumsfeld. So the case starts in the Southern District of New York. It was eventually dismissed. And I'd like to actually just go sort of right into the Southern District of New York's decision, which is the decision by Denny Chin, who eventually went to the Second Circuit, which is the appellate court above the Second District of the Southern District of New York. Essentially, Denny Chin actually, his decision, while we disagree with his decision, he actually goes out and lays out the facts. And he has about 12 different allegations that he says April Gallup claims. But then, after stating all of these things and stating what the government's position was in their case to dismiss, their motion to dismiss, he says, well, the government wants to dismiss the case because they claim that April Gallup has not made any claim. She hasn't substantiated her facts such that there would be a claim against the government. The government wants to dismiss the case because of immunity. The government wants to dismiss the case because of judicial estoppel, a whole set of other legal theories that I don't really have the time to go into. He says, I'm not going to consider any of those. I'm going to focus on the frivolousness of this case. The reason why that's significant is once you go to frivolousness, it's almost basically saying, look, I don't have to go into any legal theory. I don't have to justify why I'm dismissing this case. This case is dumb. That's really what it comes down to, and I'm just going to dismiss it offhand. Interestingly, in his decision, the judge says that he is relegated to the four corners of the complaint. Whatever the complaint alleges, that's all he can consider, which is usually true. However, if the complaint relies heavily on a lot of other external things that are not attached to the complaint, the court can consider that. Chin makes a point about that, but he just makes one point and then he moves on. And then later in his decision, he adds that even though there were affidavits attached to April Gallup's opposition to the government's motion to dismiss, that he's not going to consider any of those things because they're not part of the complaint. Mind you now, he can consider things outside of the complaint if the complaint relied heavily on those other pieces of evidence which were appended in April Gallup's motion. So he completely dismisses all of those things. And the trouble that we had, I think, primarily with Denny Chin's decision was that he mentions all of the factors that you have to take as true When there's a motion to dismiss, you have to take the non-moving party, April Gallo's position as being true. But then he just casts them away and says, I have to use my common sense as a judge. And what this complaint says is just frivolous. It's fantasy. Those are his words. He uses the word fantasy. Let's see if we can actually find it. He says, if anything, the allegations are the product of cynical delusion and fantasy. So the case gets dismissed, and we appeal to the Second Circuit. And on the panel of the Second Circuit is Judge Winter, Judge Walker, and another judge whose name I can't remember right now. But Judge Walker, the interesting about him is that he is the first cousin of Bush. So smartly, we made a motion to disqualify or to ask Walker to remove himself from the case. Of course, that's denied, and so we move forward with our appeal. When we go to the oral arguments, I'm jumping ahead now to basically the point when the judges make the decision. Ultimately, they made the decision to dismiss. But that's not sort of the fundamental problem that we had. At oral argument, after the government we give our arguments, William Veal is the one that presented the arguments, then the government presents their arguments. At the end of the government's argument, the judge says to the government, have you ever considered sanctions in this case? Now, mind you, in the Southern District, Chin already said that this case is frivolous. The government could have asked for sanctions, and they didn't. In the Second Circuit, the government could have asked for sanctions, they didn't. But the judges took it upon themselves to ask the government, have you considered sanctions in this case? And the government said, we have no opinion. So the courts went and issued sanctions anyway, to the tune of $15,000 against myself, Dennis Cunningham, and William Veal. Very angered by this, William Veal and Dennis Cunningham, they make another motion for reconsideration of the court's decision to dismiss or to deny our appeal moving forward, or to reverse Dennis Chin rather. They make a motion to ask the court to disqualify any judge in that district. Now, I was kind of troubled by this because I figured it was going to really piss off the court, which it did. But later on, some things that I found out a little bit later made me sort of reevaluate my own position on that. The courts denied this application, and they punish Dennis Cunningham on top of the punishment that he had already. Now, one of the wonderful things that Dennis Cunningham did, many of you may not know who he is, but he's an attorney for activists. He basically fell on the sword for me, personally. He fell on the sword for William and myself, but personally for me. He pleaded with the court to lift the sanctions against me, and the court did. Now, I'm forever indebted to him, because at that time, I think I've only been practicing 9 years. I'm a young attorney. What that would mean for me, and for Dennis, actually, and William, even though they're more seasoned attorneys, is that for the rest of your life, for the rest of your practice, every time you are going to get recertified, every time you're going to try to get admitted to another court, you have to tell that court that you have been sanctioned, that the court now has to consider whether or not we're going to allow this person to be admitted to our court, whether or not this is a person of high moral standard, whether or not this is a person that's going to add value to our district. What that also means is then the court is going to find out what it is that you filed that caused you to be sanctioned. And the minute they find out it's a 9/11 related case, it's going to be prejudice upon prejudice upon prejudice, and you're going to become, basically a pariah. So again, thanks to Dennis Cunningham that the court lifted the sanction against me. Remember, I said that we had made an application to have the courts recuse themselves, basically all the judges to recuse themselves. It's unheard of for that application. But later on, maybe it was about 3 years ago, I went to a CLE class. CLE is sort of continued legal education classes you have to go to for lawyers to sort of update your knowledge. For me, I think it's a racket, but that's what you have to do to maintain yourself as a lawyer. At that CLE, what I discovered was, all of those cases of like the homegrown terror cases, There's a wheel of judges that are specially selected for those cases. The reason why there's a wheel is because there are a lot of judges that are scared to take those cases because they're scared for their life. Somebody's going to come and blow them up or whatever. So it tells you that there's a sufficient amount of judges that have a built-in prejudice already about these types of cases. They don't even want to touch them. They have to have a special panel of judges that will only take these types of terrorism cases. So thinking back at it, the application that Bill Veal made and Dennis Cunningham made was actually not that far-fetched. In the Southern District or in the Second Circuit, you have a sufficient number of judges that will be prejudiced against us simply because you're bringing a 9/11 related matter. And you see it from your own walk of life, talking to people who are still not awake. So let me end on this note. Well, we also try to appeal to the Supreme Court, and the Supreme Court denied the application. So I ended a note that has nothing to do with the legal case. One of the things, I know I'm sort of preaching to the choir here, the pun is intended, but if you don't believe in some of the things that we've said, things that you've heard here, one of the things I've sort of come to resolve for myself, sometimes you have to pinch yourself and say, why am I the only person that believes this? Even though there's a whole group of people here, you kind of feel like you're crazy. There's so many people that don't believe this. On September 10th, something happened. We had certain laws, physical laws, like E = mc squared, that we believed. That existed. On September 12th, it existed. On September 11th, for some reason, it did not exist. So if you don't believe in miracles, you should now. Because on that day, that's the only explanation that I have resolved myself to, is it had to be a miracle. Because all the laws of physics and everything that we believed the day before and the day after simply did not exist. Thank you.
Thank you, Mustapha. Let me make a quick note on the Air Transportation Safety Act point about the cases related to 9/11 being funneled into the Southern District of New York. I've looked at that law. My own view is to not be completely discouraged by that, even though it's a highly unusual and restrictive rule. Personally, having read it, I don't believe that all 9/11 related cases have to go to the Southern District of New York. There are exceptions. For example, if you're talking about distinguished from terrorism and crimes by, for example, U.S. officials, U.S. corporations, U.S. residents, I don't believe the way that law is stated, those complaints would have to go and stay in the Southern District of New York. The defendants might try to move them there, but I'm not sure they would have to stay there. Also, other types of cases, like let's say someone brought a securities fraud case based on put options that were placed before 9/11. That, to my knowledge, wouldn't fall under that particular law. It wouldn't have to go to the Southern District of New York. Also, whistleblower retaliation cases have different jurisdiction, different venue, so they wouldn't have to go there. So it's not quite as draconian as it might appear, but it is bad. So let me try to finish up real quick. I know we're short on time. To give you some more examples of litigation related to 9/11 that didn't really get to the goal line in terms of exposing the truth about 9/11. I mentioned the first responders, class action, and of course the action for the family members. Those cases that are settled, they don't really get to the merits. You don't get to do the discovery to expose the underlying events. You don't get a trial to call witnesses. You don't get to subpoena people. You basically get paid, but the truth doesn't really come out when you get those types of settlements. Now, there was an international action in Kuala Lumpur where Bush, Cheney, Rumsfeld all were actually found guilty of war crimes. And so in Malaysia, there is a conviction. It hasn't been, enforced, and it's probably going to be difficult for the Malaysia officials to enforce it, but technically it is out there. Now, there is a suit against a bunch of Saudis and alleged funders of Al-Qaeda that is still pending, hasn't been dismissed yet. Initially, immunity was used to dismiss the claims against the Saudis, not U.S. government, but Saudi government based on immunity. But the Court of Appeals revisited that and actually reinstated those claims against the Saudis. So immunity has not yet prevented litigation against the Saudis. Now, the problem in terms of getting to the goal line on 9/11 truth with this lawsuit isn't that it's failing procedurally, and it may not fail, but it's really just what is being alleged in the lawsuit. The lawsuit is essentially alleging facts consistent with the official theory. It's just expanding to, more details about how the Saudis were involved in implementing the official theory or how it was funded. So this really isn't, I don't even think they would be allowed to do discovery to look at alternative theories because they aren't alleging those alternative claims. Many of you know, some of you may not, that ex-FBI agent Richard Lambert filed a lawsuit recently this year. So the short version is that case is pending. He's alleging retaliation and a cover-up on the anthrax issues. It's early in the case. He is representing himself in that case, and I would suggest to him what I would suggest to everybody, to follow that old saying they teach us in law school, that if you represent yourself, you have a fool for a lawyer and a client. But I respect his courage in doing it, but I think he would probably benefit from some help. My colleague, David Meiswinkle, will now talk about a whistleblower case related to 9/11 that I cannot talk about because it's my case, and I can't be objective on it. David?
Thank you, Mick. My name's David Meiswinkle. I am a retired New Brunswick, New Jersey police officer. I am the president of New Jersey 9/11 Aware. It's an organization in New Jersey that's trying to get a new 9/11 investigation also. And I am an attorney, and I represent mostly people that can't afford representation. A lot of it with the public defender, a criminal defense attorney for the most part. And I'm really honored to speak for a little while on this case. It's Kate Jenkins versus the EPA. And my colleague, a real gladiator here, Mick Harrison, was the attorney involved, and one of the attorneys involved. And as he said, it's up to our appeal now. He can't talk about it. But everyone here should really be excited about it. I was incredibly excited when I started to read the opinions. He provided for me 2 opinions, and about this woman who was a 31-year veteran of the EPA, a chemist, a doctor, and who had been regularly complaining over many years of things that the EPA did that were improper or if not illegal. You may know that on 2013, there were 1,140 cancer cases from workers in Ground Zero, at least reported by the New York Post. In 2014, so that was 2013, 1,140. In 2014, they reported 2,500 Ground Zero rescuers and responders had come down with cancer. And just recently, on August the 9th, 2015, which is just a little over a month ago, the number is now 3,700. So you can see that this is really escalating, and unfortunately, there were actually tens of thousands of people involved in that cleanup. So there really was a crime on the part of the government to send those people in there where there was toxic fumes, maybe more toxic than ever existed. And so Kate Jenkins, what she said was that the air that Christy Todd Whitman said was okay to breathe or satisfactory to breathe, and that the Mayor Giuliani encouraged people to go in there and breathe it too. She said it was caustic and have an alkalinity like inhaling Drano. Right? She said that. And she said it not only to her employers, people she worked for, right up the chain. She said it to legislators, she said it to prosecutors, she said it to the FBI and other agencies. She alerted everybody that was going on. This was really a toxic brew that was going to come back in their faces, or it was going to hurt a lot of people. And what did she get for that? She got fired, got canned, and she got a judge, an administrative judge, that sealed the deal with the state by bifurcating the hearing so that the state could only present their case, not allowing her to get the witnesses she was entitled to, and then finding her at fault for charges they didn't even charge her with. And but for the appeal and the attorneys involved in that, it was apparently there are some good judges. There are some good hearing officers. And there are attorneys willing to take the fight the next step. So the underlying theme here is that you can win. You can win. Now, I'm going to read some of the almost sounds like testimony, but some of what the judge said, because the second round even gets more outrageous. Is that once she gets her job back, she's going in now for a whistleblowing damages. And let me read to you what whistleblowing is. It's the Whistleblower Protection Act, or WPA, prohibits any federal agency from failing to take, or threatening to take, or fail to take any personnel action against an employee in a covered position because of the disclosure of information that the employee reasonably believes to be evidence of a violation of law, rule, or regulation, gross mismanagement of a waste of funds, or substantial and specific danger to the public health or safety. And she has to prove that she was retaliated against. And the first bite of the apple, she wasn't given the opportunity. The judge closed the door on her, found for the state. She appealed it. And on the appeal, she was reinstated. And then after she was reinstated, she went for what she deserved, damages based on whistleblowing. And my colleague was involved with cases, and she prevailed. And what happened, now this is, and we should. This is, I don't know how many times 9/11 cases have won. It's very difficult. As Mustapha told you, he's getting sanctioned by these, I don't know, political hacks or just crooks, or both, all right? They're probably a combination, hybrid. But they don't deserve it to be in the legal profession. They're not interested in justice. But what happened was that the case succeeded. She won, and I'll give you a real quick synopsis, we don't have much time, is that the attorney, Paul Winnick, he wasn't providing any discovery. Discovery is a tool to get information from your adversary. So there was all these adverse inferences a judge could make. An adverse inference is that if I ask you for documents and I'm entitled to those documents, you don't give them to me, you must be something wrong with the reason. I'm going to look at you a little suspiciously. And if I want to depose somebody and you don't set that person up for a deposition, and I can adversely infer that person could be helpful for the other side. So the whole case was like that. The attorney blatantly lied to the judge. The judge eventually caught him lying. They said there was no documents. Eventually he came after the second motion to produce 27 documents. Okay, you think that's a knot. Eventually they deposed him. There was over 900 documents they didn't allow the lady. 900 documents. And they had him on record swearing basically to the judge that he hadn't doctored some documents, which they found that he did doctor the documents. And it was a real circus. I mean, this judge was pretty good. I don't have time to read the decision to you, or the parts, I don't think I do. Maybe just the summation, because I think it's historical. The remedy, the judge says, Respondents, that's the state's shortcomings, were ongoing, blatant, knowing, and willful. Indeed, a major factor in my consideration of the complainant's motion is the breadth and depth of the respondent's ongoing disregard of its discovery obligations and failure to abide by my orders. And then she continues to talk about prejudice to the client, prejudice to the court. I mean, she was outright lied to. And Mr. Winnick on this, well, let me say, Mr. Winnick was more involved in the complainant's termination process than was previously apparent. This guy was all involved in it. That's why I didn't want to show the documents. And then he says, willful conduct, a party's deliberate failure to withhold material evidence that was properly requested through discovery is an unconscionable perversion of the judicial process. It is reprehensible when it is engaged in by a private party, but I am not sure there is an adjective pejorative enough to describe this conduct when it is engaged in by attorneys representing the United States government. Okay, and then she ruled a default judgment against the respondent for the plaintiff or the complainant, and she won her whistleblowing case, and this is a gladiator that helped do it.
Thank you. Thank you all. We need to move along, and before I introduce our colleague Vance Green to talk about FOIA, let me just give you a couple concluding thoughts on the litigation. So far, the litigation to date hasn't gotten to the goal line in exposing the real truth of what happened on 9/11 and leading up to and after. But personally, I'm not discouraged by that. I think the prior litigation is something we can build on, even though there were failures and there were partial successes. What we need to do is learn from those prior litigations, and then, and my colleague Bill Jacoby may mention this, what we're trying to do with our new lawyers group, and we haven't accomplished it yet, is to build a legal team that is analogous to what happened in the civil rights movement and the environmental movements, well-funded, well-staffed, so that we can bring a lawsuit that isn't underfunded, it isn't understaffed, it's well-researched, it's well-documented before we step into court, so that we can avoid most of these legal hurdles. And so that's one of our goals. I'm cautiously optimistic that the law still provides the power to help remedy this situation. Now, I'm not proposing litigation as the answer, don't get me wrong. What we're proposing is what we call the campaign approach. Multiple strategies, media, legislation, investigation, public education, community organizing, FOIA, plus litigation in intelligent combinations, and we think there's still the hope for significant progress if we can together implement that sort of strategy. So at this point, let me turn it over to Vance, if we're ready for Vance.
Yes. Good afternoon, everyone. My name is Vance Green. I'm the only person here who's not a professional lawyer. I'm just an average citizen. I'm the only person here who's not an attorney, just a regular citizen. I am here, though, because my sister worked at the World Trade Center on the 104th floor at Cantor Fitzgerald. So I come out to pay my respects to my sister's co-workers. She survived the '93 bombing and the 2001 bombing. I know it's not referred to as that, but so my role in 9/11 Truth is because of my sister and some of her co-workers whose families that I hope are among the few family members who have doubts about the official version of 9/11. I didn't have my doubts until 2005 or so, so I believed everything I was told about the official version for the first 4 years, so hopefully you guys will forgive me for that. After that, I'm just going to, if you guys don't mind, I'm just going to read from my prepared notes because we're almost out of time, so I can just breeze through this quickly. So I've introduced myself. We're going to get into my involvement using the Freedom of Information Act. I've been trying to use the Freedom of Information Act because, as I said, I'm not a professional lawyer, so I try the backdoor approach and try to use the Freedom of Information Act, which we all have a right to use, freedom of information, to request 9/11 related documents from the federal government. So that's what I've been doing for the last 6 or 7 years. And like Mr. Meiswinkle said, you do have victories in court. I'm going to repeat it again, but Goliath is not undefeated. Goliath can be beaten in court. I'm going to go through my notes so I can breeze through quickly. So we've all heard the phrase, the government can't keep a secret, right? Sorry. Well, of course they can. They keep secrets for up to 25 years. And the way they do that is classification. Our government claims that American national security would be damaged by release of certain information. Obviously, this is true in some cases, but each administration has tightened, renewed and tightened classification guidelines using executive orders like the one you see here. These orders are cited by FOIA officers as the basis for denying us access to records that we request using a FOIA. The beauty of this executive order is that it requires the FOIA officer to explain the damage that they claim will arise from release of these documents. And damage to the national security means the national defense or foreign relations of the United States. So when the federal government cites national security, in the case of the 28 pages, when the government cites national security, in the case of the 28 pages or the FOIA documents that I requested that you're going to see in a second, in my view, what they're actually saying is that release of those pages will harm the policymakers' relationship with that foreign country. This is a standard explanation of exemptions, which every FOIA requester receives when they do a FOIA request. It's basically a FOIA Rosetta Stone. And you'll notice B1 at the top. B1 is often used to deny us access to government records. It references the executive order that we just saw. And you'll notice it says, keep to be kept secret in the interest of national defense or foreign policy, and are in fact properly classified. Key words, properly classified. Without describing the harm as the law requires, NORAD denied parts of my FOIA request for documents regarding the military exercises conducted by NORAD on the morning of 9/11. During a March 4 interview with 9/11 commissioners, NORAD personnel revealed that the live flight exercise Amalgam Virgo, where the FBI commandeers an aircraft posing as hijackers, was actually running on September 11th. NORAD claims, as you can see here from B1, NORAD claims it is a matter of national security that we not have these documents. This is a better look at the interview, highlighted and underlined in red. You see the U.S. Strategic Command, or STRATCOM for short, used its offensive abilities to test NORAD's defensive abilities during the Joint Vigilant Guardian STRATCOM Global Guardian exercise. Underlined in red, you'll see that these exercises included hijackings. At the bottom of the page, we see that NORAD's exercise shop ran special air defense exercises, SPADES, which included aircraft reappearing and disappearing from radar, which coincidentally is exactly what happened on 9/11. The document on the right, obtained by FOIA, is the controlled staff instructions for NORAD's Vigilant Guardian exercise. And from left to right, the commanders of NORAD and STRATCOM, General Ed Eberhart and Admiral Richard Meese, established the exercise control groups, which comprised, among other things, the Blue Force and Red Force simulation cells, which are the offensive and defensive capabilities we just saw, meaning NORAD and STRATCOM were fighting each other on 9/11, among other government agencies. Coincidentally, NORAD's commander, General Eberhart, was also the commander of U.S. Space Command, and he decided to remain at Space Command where the Apollo Guardian exercise was running, both at Peterson Air Force Base. In 2014, NORAD flat out refused to even search for Apollo Guardian records, stating that NORAD is a binational organization and therefore not subject to FOIA law. We need 9/11 transparency. During their July 21, 2003 tour of the Pentagon's National Command Center, 9/11 commissioners learned that the Emergency Action Cell was monitoring all ongoing exercises in the U.S. That's on the bottom, highlighted in purple. Although classified and heavily redacted, this document obtained by FOIA is part of the Master Scenario Events list from the National Reconnaissance Office's 9/11 exercise called Tapestry Gold Zebek, which was also linked to STRATCOM's Global Guardian exercise. Focusing on the center document, we see the NRO included a 24-hour hijack in their Tapestry Gold exercise. It was called Communications Annual Readiness Exercise, or CARE for short, beginning on September 10, a hijack exercise built into TGX. Three of NRO's directors were to be all on board the same airplane, and they were all to be hijacked while in Washington, D.C. on 9/11. Why it is deemed a matter of national security that we don't have full details is a head-scratcher to me. I'm going to skip the Air National Guard exercise because I think this one is one of the most important video clips we're probably going to see. One of the most, not the most important. This is a news clip from September 11, 2001. And it looks like it's loading. If it doesn't play, I'll just tell you what it says, but I wanted you guys to see this. It's not going to play. Okay, so the news clip was from Andrea Mitchell from CNN, and Andrea Mitchell broke in to say that key FBI officials from the anti-terror team and their rescue team were away on a training exercise in Monterey, California. The caveat was that she said in her, and I quote, that key FBI officials from the hostage rescue team were training with the U.S. military, practicing for exactly this kind of event. So what I had in my notes was that this sounds like Amalgam Virgo to me. The FBI training with the military for a hijack exercise. She's on this is the news from 9/11, and she says exactly this kind of event, meaning the attacks from 9/11. Sounds like Amalgam Virgo to me. So it piqued my curiosity. I sent a FOIA request to the FBI. They only gave me 8 pages, better than nothing, but you'll see underlined in red where it says approximately half of the hostage rescue team was at Monterey. I wanted to know where the other half was. If in fact the FBI's Crisis Intervention Rescue Group, CIRG, was in fact working with the military on 9/11, then more than likely it was the Amalgam Virgo exercise. And now we come to something that I think we're all familiar with. In 2010, an online Washington Post article that should have broken the internet revealed that the CIA made fake videos of Osama bin Laden videos. You guessed it, the CIA says these videos, while neither confirming or denying their existence, they say that those videos are a matter of national security. So because no means yes in French, I sent a FOIA request to the Army because the Army took over the program from the CIA, the Army's PSYOPs, Special Operations Branch. So I sent a FOIA request to the Army, and you'll see underlined in red, the Army says they know nothing. No records response, therefore we must give you no records. Quickly, I'm going to run through this one. This is the most offensive, polarizing topic regarding 9/11 research to some people. This is very personal to me because it's happened 15 minutes away from where I live in northern New Jersey. What the hell is funny about 9/11? On 9/11, 2 Mossad operatives were arrested in northern New Jersey. The official story claims that they were conducting surveillance on the Al-Qaeda subjects. If that is true, then why would they be happy, these Mossad operatives who were seen smiling, celebrating, laughing, why would they be happy if the people that they were surveilling successfully killed their friends and allies. We used to laugh when we tripped our friends in school. We knew they weren't really hurt, they weren't dying, they weren't bleeding. But these guys were laughing. The second page on the right, I don't know how well you can see it, it shows that the FBI took cameras from these guys and developed a film. And it shows from the FBI's documents, the photos clearly corroborate blank, the witness who called the FBI. The photos clearly corroborate blank's statement in that they are visibly happy, the Israelis are visibly happy in all of the photographs. We need 9/11 transparency. It is a matter of national security, as you may have guessed. The evidence linking these Israelis to 9/11 is classified. So if there's nothing to see and they didn't do anything and they're not part of the investigation or not suspects in any way, why is it classified until the year 2030? 2030 on the bottom page, 2035 in the upper left. This information is classified. Knowing this information is absolutely useless, though, unless we do something with it. So my suggestion is that we use the Freedom of Information Act law, which they expect that we don't do. There have been several cases, there have been several successes with FOIA. George Washington University regularly kicks the government's butt in court. So there is a precedent for this. They've been doing it for decades, long before I was born. So it can be done. Again, Goliath is not undefeated in court, so if we use the backdoor approach, try to get these FOIA documents, and then use those documents in a criminal or civil complaint and append them with exhibits, I think that helps the international community and maybe even some of our more stubborn and reluctant judges to look at that package, review the exhibits, and go, yeah, I don't think I'm going to throw out this case for summary judgment. Because you got 5,000 pages here about these guys laughing and supposedly a van full of explosives, military airplanes, and Whiskey 105 outside of New York, over Long Island, which I didn't get a chance to get into. But you guys are very important. I appreciate your continued passion and interest in solving this human rights violation, the mass killings of 9/11, because it really was a human rights violation. I appreciate your support. Most of the families who started the initial push for an investigation, I'm sure they also appreciate your support. And I would really like to see everyone consider, I know you have donor fatigue, but consider donating to a legal fund so that we get into court and get these FOIA documents from them that we can then later use to append to a civil or criminal case to finally pursue justice for the murdered victims of 9/11, because it is a human rights violation, and maybe we can pursue that angle in court also. Thank you.